All right, welcome back to Law and Crime special coverage of the Shawn Diddy Colmes case. Right now, this is a live look of the federal courthouse in downtown New York, where the issue of Shawn Colmes' bail is being discussed. Now, of course, as we know, that has been denied multiple times by other judges, but this is the first time the current judge overseeing this case, Judge Arun Subramanian, is actually deciding this issue. And we're seeing back and forths between the prosecution and the defense on this. I say seeing, there are no cameras in that courtroom. Our very own Elizabeth Milner is inside that courtroom. She's going to come out a little bit later, tell us what she saw, what she heard. But what we are doing right now is providing you live, real-time updates about what is happening in that courtroom. There is reporting coming back, so I want to get into it right now. Really interesting about what's happening. Let me bring in criminal defense attorneys Brian McMonigal and Bradford Cohen, attorneys to the stars. Great to have you, gentlemen. So let me tell you about what is happening right now. So, Shawn Colmes' attorney, Alexandra Shapiro, is having a back and forth with Judge Subramanian. I'm going to read everybody the back and forth. So first, defense attorney Shapiro says, "We cited the Trump case. Defendants have greater rights to speak than their lawyers. An Instagram post, as well as I don't know if I can." And then the judge says his communications from the MDC, the Metropolitan Detention Center. Shapiro says he says the prosecution is motivated by racism. So let me just be clear about this. There's a conversation, there's a discussion about what was he saying, maybe on telephone calls to other people while he's been locked up at the MDC. The other question is, was he orchestrating a social media campaign using his family to post things online that might potentially influence a jury? So keeping that in mind, Ms. Shapiro, again, Shawn Colmes' lawyer, says, this is covered by the First Amendment. Messages they point to are not instructions to lie. There is a barrage of negative media coverage. He has a right to respond to that. The judge asks, why not through counsel? Shapiro says, we're happy to do that. Shapiro says, but we're lawyers. It's not really what we do. Some of these recordings shows that he's telling people, just tell the truth, talk with my lawyer. And then the judge says, victim 3, you're saying the communications are fine? And Shapiro says, yes, same on witness 1 and witness 2. The judge says, what about the communications that are missing? Agnifilo, this is Mark Agnifilo, this is Shawn Colmes' other lawyer, says, witness 1 reached out to Mr. Colmes' counsel and asked us for a lawyer. We didn't do anything along those lines because it was an odd request. I don't know the factual answer. The judge responded, how do you know not now? How do you know no? Or how do you not know, maybe? Oh, it's how did you not know? That's exactly. How did you not know? And Shawn Colmes' other lawyer, Tenny Garrigo, says, there was a message from Mr. Colmes to witness 1. I'll like to give it to you under seal. Prosecutor Foster may know it does not give rise to the level of obstruction. I do not have the actual message. Brian, I'll start with you. A lot of back and forth here. It's about whether or not his communications are a form of obstruction. It's about whether or not him even initiating a social media campaign would be to improperly influence a jury. This all goes to the issue, is he a danger on the outside? Is he flouting the rules inside? He cannot be released outside. What are you taking away from this back and forth I went through?
Well, the fact that they're debating it is healthy for him. It sounds like our judge here is trying to give a real fair analysis to all this. And this is a collision between First Amendment rights, as far as I'm concerned, and some of the requirements under bail, if there should be bail given. You're not supposed to have contact with witnesses. You're certainly not supposed to intimidate witnesses, but you're also able to defend yourself and marshal a defense and speak your mind as a defendant. And judges always have a very difficult time trying to balance those two constitutional issues. And I think this judge is struggling with it because this is a man who's on trial for his life. His liberty's been taken away from him, and he's fighting back. And that would be something that one would expect of someone who's been accused of heinous crime. So I think that today is probably, as I think you've described it, really the first opportunity for there to be a healthy debate on why he should be released.
And Bradford, I want to give you an opportunity to respond to that as well. I do want to let you know there was another update where Ms. Garagos, who again is one of Shawn Colmes' attorneys, says, my client obeys me. For example, on victim 3, he stopped using ASAP and other phone lines. The messages with witness 1 were pre-arrest. He obeys us. He came to New York. In the Bureau of Prisons, when I tell him not to do something, he does it. So in other words, if you have concerns about him flouting the rules, he will listen to us. We'll tell him what to do. What do you think?
I think that's an argument that I've often made, and I think a lot of defense attorneys make, in terms of that our clients will listen to us if we tell them what to do and what not to do. And in certain circumstances, you have clients that have not been in a situation like this before, where they're in custody, where they are getting a barrage of allegations against them. Some may have some basis of truth and some may not. And you've seen that over and over again in this case. There have been reports of different things that went on and different allegations against Shawn Colmes that they have then found out, oh, these are just rumors and they're not true. I think that it's not a bad thing when a PR company or even when a defendant takes it on himself to have family members talk about the good thing that he's done in the past and the charitable things that they've done in the past. When you have a case like this, where they are just every day, there's something that is coming out, something that is leaked by either the government or a party that's involved or someone that's interested in the case, where it is affecting, that could have affected a jury. I think that, that release of that Cassie tape, and I keep going back to that release of that Cassie tape, I think the tape was released because they knew that she was going to be somewhat blamed for the behavior that happened, that they would know that she would participate in these different things with different individuals, and they wanted to make sure that was cut off at the pass and essentially make her a victim and not a co-defendant. And I think that's why that tape was eventually leaked by whatever party that leaked that tape. A lot of not going back to that. No one's really discussed how that tape has come out, and I think it's an interesting thing. And especially when you have a judge that's interested in your story, and you have a prosecution that is interested in why he is making these, these PR moves on social media. I think it all comes back to that tape. And I think that's their strongest, quote unquote, strongest piece of evidence in terms of their star witness to say, hey, this guy's a bad guy. I do like the fact, and I will agree with Brian, that the fact that they're having a conversation, that the judge is engaging them, is always a good sign. Is it, the end all be all that he's going to grant him bond? I don't know. I think this is a tough hill to take. I think it's an uphill battle whenever you have an individual that's facing the type of time that they're facing and the type of allegations to get a bond. Certainly the bond package is pretty extensive in my opinion. A $50 million bond is nothing to sneeze about.
And to go into that, about one of the areas where I think Judge Subramanian seems to be receptive. He actually told prosecutors early this week, be prepared to talk about this. It's coming up right now, and Brian, I'll ask you about this. So this, Ms. Shapiro, who's Shawn Colmes' lawyer, says, I submit the charges in the Jeffries Abercrombie case are worse than here. They allege an international sex trafficking business. They were raped and forced to engage, and I'm not going to say, but in a certain kind of sex acts. And by the way, the argument here is, and this is what the Judge Subramanian said, is distinguish prosecution why it is Shawn Colmes, after putting forward a bail package, as we said, $50 million, 24/7 private security firm, limited visitors, visitor logs, no internet use, no phone use. Why is he denied bond when you have Mike Jeffries, the former head of Abercrombie & Fitch, who was just arrested and charged with sex trafficking? Why is he out on $10 million bail? And by the way, the prosecution responded earlier, and they had a back and forth about this. He's 80 years old. Shawn Colmes is 55 years old. Shawn Colmes is charged with racketeering. He's not charged with racketeering. Shawn Colmes has alleged instances of prior violent behavior, not the instance with Mike Jeffries. But here you're seeing, Brian, where they're saying, we actually think the Jeffries case is worse. What do you make of that?
Well, it's brilliant. And I think that's the road they have to travel because it's precedent. You know, you're not supposed to have different rulings for like-minded cases. Disparity in treatment is always frowned upon in the federal courts. And here they have a significant public interest case where bail was set at $10 million by agreement. It wasn't debated over. The government agreed to it. Now we come over to Shawn Puffy Combs's case, and they're objecting to 5 times that amount for someone who I don't believe has ever been convicted of a federal crime or a felony. I could be wrong about that. And they're putting restraints in place that make the previous bail package pale in comparison. So they're right to make this argument. It's precedent. It's precedent within that jurisdiction. And I think the judge is going to look hard at it. You know, you've now got 2 rulings that have gone against him. So he's got to look at those rulings and those judges. But he's also got a situation where the government has agreed to bail in a situation that's, if it's not as bad, it's pretty darn close by accusation.
And look, I think they could, you know, look, it's also a different court. This is a different, this is the Southern District of New York. That was the Eastern District of New York. But even you put that difference aside, this seems to be one of the more compelling arguments put forward by the defense. Bradford, we're also taking questions, by the way. So anybody who has questions about this case, submit them on YouTube. If you have questions about the hearing, submit them. We have this interesting question from Sahara Useri on YouTube. Why did Colmes get a new judge to begin with? It's interesting, right? Because I believe we had a district court judge or a magistrate judge, then a district court judge, now Judge Arun Subramanian. Why do you see a reassignment of a case like this? Why is it now in the hands of Judge Arun Subramanian? Why do you see this happen, Bradford?
Well, on federal cases, we always appear to begin with in front of a magistrate. That's usually the first person who hears the case, if it's a bond issue, and or if it's even a preliminary issue. A lot of times, court judges will give magistrates the power to rule over different kind of motions to suppress and motions to dismiss. But we always go in front of a magistrate that's associated with the judge, and then generally you then go to the judge that's going to have your case. It just depends. Sometimes you go to a temporary judge until it gets assigned. A lot of times judges don't have time for the type of case that it is, or they might not have the schedule that will behoove a trial in a certain period of time. I believe that this trial is being set for April, and it might be the other judge that was assigned already has a case that's set for April. That's not uncommon. I don't see that as like unusual. We've seen that in many cases. I've had many cases where judges have changed at the beginning of the case. It's usually unlikely that at the end of the case that you have a judge that'll change once they've heard motions and once you've done discovery and things of that nature. But I don't find anything of that unusual. Magistrates are always common. You always go in front of a magistrate first, and those are usually randomly assigned. And then a judge is randomly assigned, and then another judge can take over at any time. It's not that big of a deal.
And by the way, I wish we had cameras in the courtroom, but based purely on the arguments that we're seeing and have seen with Judge Subramanian, I feel confident to say this feels like a very fair, well-reasoned judge. The way he was pressing the prosecution, the way he's been pressing the defense, it's really something to take note of. And that's kind of the judge, that's exactly the kind of judge you want in these cases. There's a question that we have from Samian on YouTube. I'm curious, Jesse, why did the prosecutor not reference the R. Kelly trial? They might not have referenced it today, but it was in their filings. I think it was even in the very first bail filing. They referenced the R. Kelly case. They referenced the Jeffrey Epstein cases as why it would justify bail for Shawn Colmes. Here's another question. I'll throw this over to you, Brian, from Europes Hunar on YouTube. If Diddy gets out of bail, does that mean that he gets out immediately, like this hour?
It'll happen pretty quickly. He'll have to go back. Usually you have to go back to the detention center that you're being housed in. There's some paperwork that has to be done, but I would think it would happen pretty quickly. It would be tonight. Unless there's some other snafu that occurs in trying to get it done. But for a high-profile case like this, they'll move quickly on it. All the eyes of the world are watching it. I think it'll happen pretty quickly. It'll certainly happen, I think, sometime tonight, if he rules tonight. I mean, that's, some judges recognizing that there could be an appeal of this ruling will take the time to issue a written opinion. And that would be the only reason I would think this judge would hesitate before ruling in this case. He seems, as you've described it, to be a really fair-minded and thoughtful guy. That is his reputation. And some of those judges that are more thoughtful and more fair-minded issue written opinions, which he may do in this case.
We have another update from court. Ms. Shapiro, again, defense counsel for Shawn Colmes. While in Jeffrey's case, one defendant is 80 and the other is 71, Mr. Colmes is 55. I hate to say it, it's not that young, because that was one of the things the prosecution said. Like, you're
Objection.
dealing with an 80-year-old. Yeah, you're dealing with an 80-year-old. You're dealing with an 80-year-old. He's 55. You know, he's much younger. He's more of a danger. The judge says the U.S. suggests he won't follow conditions. Shapiro says these conditions are more restrictive than in the prison. Again, I kind of laid out what some of the conditions are. Bradford, your thoughts?
I think the argument that one guy's 80 and one guy's 55 is, if I was a judge, I think that would fall on deaf ears. The 80-year-old might be more willing to do something crazy because he's 80. You know, it's like he only has so much time left. Anytime you give an 80-year-old is going to be a life sentence. So if the guy gets 5 years and he's 85 years old, that's not that young. So the argument itself is not great about the age. I think the stronger argument is maybe that in the RICO charges, they're charging some sort of violent behavior. That's probably a stronger argument because the Abercrombie and Fitch CEO doesn't have a history of alleged violence or participation in violence. But the allegations of the sex trafficking are very, very, in my opinion, are worse for the CEO of Abercrombie and Fitch. And it's just, you know, it's funny that it just by happenstance, these cases happen together. If it didn't happen together, you'd have nothing to compare it to. You'd have to go back to a different sex trafficking case that someone didn't get bond. So it just so happened that this worked out for Shawn Colmes, where the Eastern District comes to an agreement on the CEO of Abercrombie and Fitch, and it works in his favor. I think that you have to lean very heavily on this guy could make a run for it at any time, right? It's not just that he's a danger, it's also that he's a flight risk, they were arguing. He could have made a run for it at any time. He has jets, he could have gone to Mexico, he could have gone anywhere, and he never did. He surrendered when he was supposed to surrender. In fact, they didn't even allow him to surrender. They picked him up at night at a hotel when they knew that they could have called him and he would have just surrendered in the morning. I think that it goes to show a lot of bias, obviously, on behalf of the U.S. Attorney's Office. And I think a judge like this judge, who used to be a clerk for really, really good judges and was in the commercial business world and kind of looks at things that way and looks at objectivity that way, I think was a real, real good thing for Shawn Colmes here, because a lot of other judges that have been kind of jaded by the criminal system might not give him as fair of a shake as this judge is. And this judge is fairly new to the bench, so I think that benefits Shawn Colmes as well.
It's interesting you say that, because I want to read you the latest from court right now. So the judge says, Mr. Agnifilo, where is the home he'd be in? So again, if you're talking about home confinement, Agnifilo says, I don't want to give the address, but it's on Star Island. There's a causeway. This is in Florida. This is Miami. There's a docks, but there's a dock, but there would be no boat. The judge responds, that's not going to work. We're in New York. Agnifilo says, give me a moment. He comes back and he says, there is an apartment on the Upper East Side. We have one available, 3 bedrooms. The judge says, where are the 24/7 security going to be? Agnifilo says, would you like to speak to him or me? It's Patriot Security. They merged with Crisis 24. So, Brian, now, is this just the judge doing his full due diligence about understanding what bail would look like, or is this kind of potentially a sign of where he might be going? And by the way, we have another update. He says, Agnifilo says there'd be 2 security guards in the apartment and 1 downstairs, so a total of 3. No access to phones or the internet except for calls with counsel arranged by the security personnel. This is more restrictive than in the MDC. Brian.
I think he's leaning toward letting them out. The response to by the judge, by the way, about jurisdiction is crucial. Most courts, no matter where you are, if they're going to release you, they're going to release you to that district. And so I was kind of surprised that the bail package didn't originally provide for that, because no one's going to let him go to Florida. But I think this judge is giving real serious consideration to letting him out. Think about it. All the headaches go away. We don't got to worry about the FDC. We don't got to worry about what's happening at the FDC. We don't have to worry about counsel complaining about the fact for the next 9 months that they don't have true access to discovery, that the defendant doesn't get discovery, that the defendant doesn't have the opportunity to defend himself with counsel. All those issues go away for you as a judge. He's not running anywhere. And if they're right, and he's foolish enough to engage in threatening behavior while he's out on bail, that will be the first piece of evidence they introduce at his trial. So I think the judge is a pretty smart guy, and I think he well realizes that the original bail package probably should have been something that they gave serious consideration to. You know, he's presumed innocent. You know, the presumption of innocence all of a sudden fades away when we talk about celebrities. But he's presumed innocent in this case, and bail is for people that are presumed innocent, and he is.
And for the prosecution's point of view, you know, in one hand, if he is let out, engages in obstruction, they can not only have the bond revoked, but gives them more evidence for potentially a superseding indictment, more evidence for at a trial. But the downside is they don't want to be in a position where witnesses are threatened or intimidated and don't cooperate with the government. So it's kind of a tricky situation here. We have an update here. Bradford, I'll go to you. Ignifilo says, Mr. Colmes would avoid all contact with anyone who may be a witness. I think he has a right to do that, but I want to make it as easy for the court as possible. We are going to investigate thoroughly before the May 5th trial. He has a right to assist. Your thoughts?
I think that, like I said before, I think that, you know, every argument that they're making is falling on ears that are open instead of deaf ears. Whenever you're a defense attorney, and Brian knows this as well as I do, and you're representing a high-profile individual, sometimes there are preconceived notions, and the judge has kind of already made up their mind while you're arguing, and you can see it in their face. They might give you a what seems to be a fair shake, but ultimately they have made up their mind. In this case, as the argument is progressing and his attorneys are adding on to the bail package that he's not going to have any contact with anybody, he's not going to have any phones. And a lot of times when I have clients, high-profile clients in federal or state court, and I offer 24-hour security, I usually hire ex-FBI, ex-DEA, and I'm sure the company that he has is probably along those same lines that give credibility to the security that's going to be watching him and making sure who's checking in and who's signing out and things of that nature. All those things add up in a judge's mind to assure them that they're doing everything possible to kind of stay out of the way and not get in trouble. I honestly do think, listening to what's going on, the judge is giving serious consideration to allowing him out on bond, which to me is a surprise because a lot of times in federal court, you don't get that fair shake. When you have these allegations and you're representing someone who's high profile, a lot of times these judges have made up their minds. I mean, we want to feel like every judge is fair. We want to feel that the judicial system is fair, but a lot of times that the judges have already made up their minds, and it's very difficult to get a bond on this case. And I think that his defense attorneys are doing an excellent job in putting together this bail package and explaining it to the judge and coming up on, and often you find yourself doing this, coming up on the fly where the judge says, hey, that's not going to work. Florida's not going to work. I need something else. And it's like, yeah, I got an apartment on, the Upper East Side. It's a 3-bedroom apartment we're going to put him in. That's not easy to do. And it is a hats off to his defense for coming up with those things on the fly and being able to modify their argument that way. And I honestly think when a judge starts asking questions like that, he's very strongly leaning towards granting a bond.
Well, it's good when you're a multimillionaire. You could just, where am I? Where's this case happening? Yeah, I got a property around the corner. Let me ask you this. So this was brought out by the prosecutors earlier on where they said, okay, want to talk about the security team? So they say, because the judge asked, what are we talking about? They said, what type of security team? He's suggesting a co-conspirator, one whose phone was taken only the day before. The second suggestion, was a defense investigator in this case. That investigator has been out contacting witnesses. Essentially, they work for him. So the reason I bring that up is because the judge just said the government is saying Mr. Colmes would be paying these people. It comes down to trust. Mark Agnifilo, again, Shawn Colmes' defense counsel, says it's a different relationship. There are professionals that are only going to be in his life for 8 months. It's a high-profile case. He goes on to say he's been in jail 66 days without a laptop. He only got one a few hours ago. What is unique here is to have waited 9 weeks to get a laptop into the MDC. The judge says the solution is for you to come to me. We can call these hearings, which get things done. Okay, so that's a separate issue about what the resources he has. The question, of course, Brian, is can you trust the security team? Prosecutors say, A, they have the connections to him, but B, even if they didn't, he has a way to compromise people. If he's in prison, if he's in jail right now at the MDC and he's using inmates' PAC numbers to make phone calls, that's the question. Can we trust the security team? What do you make of that?
As my brilliant colleague just pointed out, the way to go would be to make sure that you've explained to the court that you've got a team that is beyond reproach. And I'd be a little stunned if that's not the case. They should have former FBI, former New York police, somebody that when the judge hears their bona fides, he's going to say, you know what, this is somebody who's got some intellectual honesty. This is somebody who's not going to risk their reputation for a payday. And so I would expect that if the judge does release him, he's going to want to see that. He's not going to want just somebody on this guy's payroll to be overseeing him, during these 9 months, I can assure you. So I'm surprised if that's not the case.
Right.
And knowing Mark, as I do, who's a preeminent lawyer, they'll make sure it is the case. If they've already provided a team, they'll get a better team. If that's an issue with the judge.
Let me ask you this, Brian.
Jesse.
I'll ask you both this because this is a question that we got from one of our YouTubers, Floss Daily. Who pays the security company? If Diddy's paying it, is that a conflict? I'll allow either one of you to address that. If Bradford, you want to address that?
Yeah. Sure, yeah, because I was going to add in, it's an absolutely great question. And what I do is to kind of take out the stench of any kind of impropriety that you think could go on. I figure out, okay, if it's 24-hour security for 8 months, it's going to be $250,000, $350,000, whatever it's going to be. And I instruct my client that we put that money in my trust account and that or a company is hired to pay them separately from just the defendant. So they're not relying on the defendant to get a paycheck. It kind of takes that sting out. I mean, there's always going to be a sting of, hey, I'll give you an extra $1,000 if you do X, Y, Z. You can never kind of get rid of that kind of thing. But you can take out one of the links in the chain and say they're going to be getting their paycheck from either ADP or they're going to get the paycheck from my law firm, but they're not going to be relying on the defendant to get paid, and they can't be threatened like, hey, you're not getting a paycheck unless you let me use your phone. A lot of times that also helps in these situations where a judge is asking about, how is this going to work with this 24-hour security? And they're going to be behooving to him because he's the one who's paying it. I think it takes out one of those links, and it also benefits the court's decision. It eases their mind on that issue.
Brian, I'll give you an opportunity to respond to that, but we also have another update from court. Mark Agnifilo says, I have a whole presentation ready about the tape, but if you've got enough, I can save everyone 15 minutes. The judge says, I have reviewed it. Who is here from Pretrial Services? Pretrial Services comes forward and says, we maintain conditions are insufficient. The judge says, have there been other cases with private guards? Pretrial Services says, not that I'm aware. What do you think, Brian?
Happens all the time. Pretrial services, they do a great job, but, they're a government entity. And in a case like this, the default position always for pretrial is going to be detain. It's easier for them to do that. This judge knows that. One of the other things that came to mind while I was listening to Bradford was, I wonder if the government didn't do themselves a disservice by this untimely search of the cell,
Yeah.
where they
Yeah.
shook his cell down. They allegedly looked at privileged materials. That's a no-no. And I don't think this judge was all too pleased with it. And I think he started doing the math in this case and started thinking to himself, it may be easier for everybody, including the government and the prison officials, if we let this guy pay a lot of money for a private security firm to keep him from fleeing, and we'll get this case tried in a timely fashion. I won't be running into court every week or two with a complaint about discovery. He didn't get his computer. We've got so many terabytes to go over. We don't have the ability to defend. It puts so many issues into a case that can be easily resolved with agreeing to the bail package. So it was just another thought.
And
Yeah, Brian's
Bradford,
100%
yeah,
correct.
Bradford, jump in on that. Yeah.
Yeah, he's 100% correct. So, first of all, there's been cases in New York. I've had cases in New York where we've recommended private security and got granted private security. And around the country, when you look at these high-profile cases, there's been many, many cases where private security. One of them is an NBA YoungBoy who had a case in Louisiana. He had private security as part of his bail package in Utah. Kodak, who I represented, he had a private security as part of his bail package. It's happened many, many times. And I think the number one takeaway that Brian is so right on is that this searching of his jail cell was so very stupid by the government, and they just can't help themselves. Like it's really sometimes, they can't help themselves. Even when they have cases that they feel are good, they want more.
Just to be fair, they said this sweep of the MDC was comprehensive. It wasn't just aimed at Shawn Colmes. His defense team says it was a pretext, but just to give you the other argument.
I have a very cheap bridge for sale for you. Listen, I think that this was I think it was a pre-target. I find it very hard to believe that it wasn't. You had a specialist that was there that normally is not there. He's taking pictures of items that have nothing to do with what they're searching for, phones and drugs and things of that nature. I find that very hard to believe, and it just is shocking sometimes when you look at the government when they have so much power. They have so many assets that they can use to obtain guilty verdicts, and they want more. They always want more. And in this case, I think this bit them in the behind. I think that the only reason this judge is being so I don't want to say he's being so reasonable. The only reason that this judge has considered some of these arguments, I think, and they're not falling on deaf ears, is partly because of the prosecution's dream that this was just, this was something that was going to happen, and we didn't mean to get his notes. And even though we had his notes, we had a team. We put up a Chinese wall. They have every excuse in the book. But once you taint a case with something like that, it's very hard to regain a judge's trust. And I think that's why a lot of these questions are being asked of the prosecution. And in addition to this guy who got out, the CEO of Abercrombie and Fitch, I just think a lot of things came together for Shawn Colmes to give him this opportunity. And this is his best shot.
So we have another update from court where the prosecutor has now jumped in and said, consider witness one a participant in multiple freak-offs. Defendant continued to contact witness one after counsel was retained. The Instagram post was planned for a week using Contact Me ASAP and other inmates' codes. Really, really interesting there about that, basically suggesting that Shawn Colmes is engaging in obstruction. I wanted to ask you, we have a question from one of our viewers that I think is fascinating. And Brian, I'll throw it to you. Are there any additional bail conditions the judge could impose on Shawn Colmes? Could the judge place Shawn Colmes under the supervision of the Federal Probation Office?
I have never seen that being done. I mean, anything that the probation office could do would pale in comparison to what the defense has already submitted. You put somebody on a bracelet. I mean, they don't have the resources to have 24/7 guards in the U.S. Probation Department. More importantly, that's not their role. So, fair question. Why not have the feds protect him and police him while he's out. It's not the way the system works. And more importantly, I think to all of this is, there has to be an ability for somebody to defend themselves. And what the prosecuting team seems to be relying on here is his efforts to really defend himself. He is looking for help. He is looking to try to line up witnesses, to marshal a defense, to reach out to allies, to get friends and family to get on social media so he can start not winning the battle, but just try and making the landscape a little bit easier and more even. And so I don't know what this judge is going to do, but I would tell you constitutionally and legally, the easy thing to do would be to allow this bail package to be put in place. And the worst thing that could happen for the defendant would be if he spit in the face of the court once the court gave this to him.
Yeah. And by the way, that brings me to another point. So Bradford, we have an update from court. The question becomes what he was allegedly doing while at the MDC. We can have a back and forth about whether or not he was actually engaging in obstruction and what the contents of his messages were, versus was he just violating the Bureau of Prison rules. If they tell him not to make a phone call or they tell him not to do this, whatever the contents of it were, if he violates the rules, the idea is he violates the rules of the Bureau of Prison. What makes you think he won't violate the rules of his bail? The reason I say that is because the prosecutor said his family member said the lawyers say not to do it, and the defendant responds, "I don't care, it's my birthday." This is in regards presumably to that whole social media campaign about surrounding his birthday and the birthday video. So the idea would be he just didn't care, he violated the BOP rules. The judge said, Ms. Shapiro said sharing codes is common with other inmates and the conduct was covered by the First Amendment. The prosecutor says, the Bureau of Prisons handbook prohibits this. So it becomes a question, the content of what he was doing, Bradford, versus did he just straight up break the rules? And if he just straight up broke the rules, is that a concern for why he shouldn't be granted bail?
So the rules that he broke are broken on a daily basis. Like it's so idiotic when they just overshoot every time and say like, oh, it's three-way calling. He broke the rules. I don't even know how many times. I'm sure Brian has been through the same thing. I don't know how many times our clients call us with three-way calls and using someone else's PIN. And it's not that they want to discuss anything. It's all attorney-client privilege when they call us, unless it's a three-way call and there's someone else on the line, then it's not. And I always let my clients know that. But a lot of times they'll use other people's PINs for different reasons. Like even when they call me from a different PIN, it's because they feel like the government's still spying on a discussion between them and their lawyer. And they could be right. It's not like they're wrong. And a lot of times, or they want to call, they're married and they want to call their girlfriend. So they use, one of the other guy's PIN numbers. It's so commonly done that I don't even consider it a flagrant violation of the rules. I don't even know if they give shots. And what a shot is they give them some sort of a warning or some sort of pink slip for using someone else's. I don't even know if they do that anymore because they're more concerned with the drugs and the cell phones and things that are snuck into the jail. This is such a minor violation that the government here is saying is such a massive violation that unless they can really tie it up with that he's doing it to contact these witnesses and threatening witnesses, if the judge has real life experience, which I'm sure this judge does, he's going to look at that as a very minor violation of the jail rules. And I don't think that shows that he's going to flagrantly do things if he's let out. I just don't think that's a good argument.
Well, here's the question. This is a question from Jasmine Milan on YouTube. I'll throw it to you, Brian. Couldn't he just have his family members do all the things that he isn't allowed to do? That would be the question in terms of if he's out.
If he's out. Yeah, I mean, I think we end up chasing our tails with some of the issues here. I mean, if he's out, he's going to do everything he can to defend himself. If he's in, he's going to do everything he can to defend himself. If he's in, he's got to jump through all these hoops to have contact with the people that are going to do everything they can for him to defend himself. Remove the hoops. You know, Bradford's got it right. I think I got 4 three-way calls during this session. For God's sake, it's happening. You know, there were probably 20 of them from from this detention center while this was happening. It happens every day, and it goes back to that central thing that I keep thinking. You know, this judge seems like a really brilliant guy. The headaches here are all driven by the fact that they've taken away his liberty before his trial.
Right.
All those headaches, every single one of them, put aside for the sake of argument the government's concern about threat, every one of those headaches that inure to the defendant in terms of constitutional protections go away.
Yeah.
All of the headaches for the court in policing this go away. They become somebody else's problem, and know well that if there's one issue, somebody goes sideways a little bit, somebody makes a phone call somewhere,
Right.
he's detained within 5 minutes of that incident. So
Right.
the easy thing to do here, and I've been kind of, saying this for a month, is to let a guy have a $50 million bail package.
I'm going to give you another question, Brian, because you know what? You're right. We've been beating the same kind of drum a little bit. I have another question for you from one of our viewers. Before I get to that, let me just give everybody an update about what's happening in court. Prosecutor says defendant has used at least 8 inmates' codes. He's bought them. The judge says they say Contact Me ASAP operates through TrueLinks, the trust fund limited inmate computer system. The prosecutor says it's not permitted. In the Jeffries case, one is detained, and the judge said that's a foreign national. Okay, so making a little distinctions here. But I do have a different question for you, Brian, if I could find it, if I didn't lose it. This is from Latoya on YouTube. If he is convicted, Brian, and sentenced to prison, what happens with the civil lawsuits?
Well, I mean, the civil lawsuits may all at some point be indefensible. Once he's convicted, I again, making sure all those civil lawsuits have some relationship to the charges here. To the extent they do, they become indefensible. There'll be a conviction. That conviction will be part and parcel of the evidence in the civil case. He'd have to be deposed. If he was deposed while his case is on appeal, he'd have to assert the Fifth Amendment. The Fifth Amendment is an admission in a civil case. Those cases, if they are related to this event and he is convicted, become indefensible.
All right, we have another other update. Prosecutor says this is more similar to the cases where detention was ordered, talking about R. Kelly, Keith Raniere, Larry Ray. Bradford, if you're sitting in that courtroom and you're representing Shawn Colmes and the prosecution mentions these other people, R. Kelly was charged with sex trafficking and racketeering. How do you distinguish Shawn Colmes from those cases?
Well, the funny thing is, and it's not that funny, is that different areas have different issues with bond and how bond packages are done. In the R. Kelly case, I don't think, number one is they came up with $50 million. They didn't have 24-hour security. They didn't have electronic monitor, taking away his cell phones, his computers, etc. They didn't have any of that. So if you want to compare apples to apples, I think, and my opinion, is that the best case scenario is that Abercrombie & Fitch CEO. I keep going back to it. It happened very soon in time. It was in an area that is right next to New York City, which is the Eastern District. He was allowed to surrender. He was given a $10 million bond. The guy still, nobody even knows. If I was in a room with the CEO of Abercrombie & Fitch, I wouldn't know him from anyone, right? If I'm in a room with Shawn Colmes, I'm going to recognize him right away. So it's a little bit of a different situation. The CEO of Abercrombie & Fitch can disappear to Morocco. No one's going to recognize the guy.
He's got, right? I mean, have you seen his face? He's got a quite a distinguishable face, but that's a separate kind of issue. But anyway,
I have. And the common man does not know who the CEO of Abercrombie & Fitch is. I would argue that Shawn Colmes is known pretty much worldwide, especially even at this point. And that, I think, lends itself to, really distinguishing him from the rest of these individuals. And we always say, like, hey, money does this or money does that. And it's true. Someone without substance might not be getting a bond on this case. But that's the whole point of bond, is that it shows your commitment to appear in court, to not violate the rules, to do these certain things. So as you have more money, obviously the bond is higher in amount to make that more of a damaging thing. Like, someone worth 100 million, if I put up 50, that's really hurts me, right? It's just like if someone was $100 and they put up 50. So the thing is that that's the difference between Shawn Colmes and these other cases, is that his bond package is completely different than what was being offered in those other cases. And the fact, I can't get beyond the fact that he just stuck around. He didn't go anywhere. Not that he could have. I'm sure the feds had their eyes on him 24/7 before they filed charges. But he stuck around. He didn't go anywhere. He informed them of where he was flying, when he was flying, where he was going, when he was going, during that whole period of time. And then when he knows that he's going to be arrested, he flies to New York in preparation. And instead of allowing him to surrender, like they would allow anyone, I mean, he's there to surrender. Instead of allowing him to surrender, which a judge would have looked upon that favorably and said, oh, he surrendered himself, they go to his hotel and they pick him up at 9 o'clock at night. It was a real, to me, spit in the face. And I think the reason they did that is because they knew that Shawn Colmes was trying to organize this PR thing and was trying to put on a good show in terms of, hey, listen, mea culpa, I didn't mean anything on this video, and I'm going to rehab, and all these things that are good for his case. They got, I think, frustrated that the perception was starting to sway a little bit. And then that Cassie tape came out and perception kind of went down the toilet, because once you see it on video, it's very difficult to then you see all your friends kind of abandon you. So, it just frustrates me when you got a guy that is willing to do all these things and you still, don't want to agree to a bond.
So I know we've been keeping you guys for a while. We're going to take a break. Before we do, I want to get some final thoughts, but I want to give you some updates from court. And Brian, I'll start with you on this. The judge just said, I suggest both parties put in letters by Monday at noon about what type of communications Mr. Colmes may engage in. Monday at noon. So that's interesting to think about. What is he mean? He's going to be out or he's not going to be out? But his lawyer, Colmes' lawyer, Tony Rico, said, we have to email for a week to get him a file folder. Then he said his adult children are willing to obey. He's not a lawless person. We spent hours at the MDC. Mr. Colmes was writing down what I said. He's not out of control. DOJ is responsible for the MDC. Those phone calls from me all the time, and I hang up. Just your thoughts on what we're hearing here.
I go back to it. I think this judge is really giving serious consideration to allowing him out and trying to figure out a way to do so where the government's concerns are alleviated, to stop communications, to prevent the wrong kind of communications. A lot of the listeners that have asked questions are seeing, justice play out here, and what a difference a judge makes. There are a lot of judges I just listened to Bradford's arguments, all brilliant, that would listen to it and say, thank you very much, have a seat, denied. This is one of those judges that listens. This is one of those judges that balances. And what a difference a judge makes. And he could very well, if not today, Monday, make a decision that's favorable to Mr. Colmes.
So speaking of which, we have another update. Mr. Rico, again, his attorney says he has access to cell phones in the MDC, but not under our conditions. He fights, he kicks, he makes phone calls. This can be addressed. Thank you. Judge says we're going to get a decision out prompt next week. Bradford.
Yeah, I think that's the smart thing to do. Listen, smart judges don't just make decisions off cuff, right? They go back to their chambers. They think about it. They have very, very smart clerks that know the law, that give them case law to back up their reasoning. And, judges sometimes have gut feelings when they've been on the bench for a long time, and lawyers too. We've been doing this for a long time, and you have a gut feeling what's right and wrong, and then you got to find the case that tells you that you're right. So I think that it's smart. I think that smart judges put out smart orders because they know they may be appealed, or they know it's going to be publicly read, and that's just what they do. So I'm not shocked that he didn't make a ruling from the bench. Just as Brian said very early on, he wouldn't be surprised either that the judge is going to take some time and do a written order, because that's what good judges do. Good judges do written orders. They don't shoot from the hip, and they don't automatically say one thing or the other. They think about it. They sleep on it. And I don't know how many times I've been in a case where I'm feeling like, oh man, this judge I feel like they're ruling against me. And they say, hey, listen, I'm going to get a written order out, by the end of the week. And then they go back, they read the case law again, they find new case law, they find, all kinds of different things. And then they rule in my favor maybe for a completely different reason than was even discussed at that hearing. But that's what really differentiates great judges from just guys that are, that have been on the bench for maybe 30 or 40 years, and they're kind of going through the motions, and they know what to deny and what to grant and why to deny it. And they just kind of, they're on autopilot. Like I said, when you get a judge that is fairly new, it's usually very refreshing, their take on certain issues.
I agree. This is a judge that's very refreshing. I think he's really carefully considering both arguments. As you said, right now the latest update is that he wants those letters Monday. We'll make a decision next week. This could possibly be Shawn Colmes' last weekend behind bars. We will see. But the court has been adjourned. Gentlemen, let me tell you, Brian McMonagle, Bradford Cohen, thank you so much for your brilliant insight, your analysis, your generosity with your time. And let me just give you one last suggestion. Imagine you two teaming up. My gosh, what a power team you two would be together. So let me just leave you guys with that.
I'm calling him now.
You guys really should. My gosh, it's two brilliant minds.
I have long admired Brian's work, and it's always great to be on with individuals that have been in the trenches, that have actually tried cases, that have been doing this for a long time, because warriors generally think alike, and it's always good to be on with someone like Brian.
That's
high
great.
compliment coming from you, my friend.
All right, gentlemen, thank you so much. Really appreciate it. Thank you, everybody. We're going to take a quick break. Elizabeth Milner is coming out of that courtroom. She's going to give us a live update about what she observed of Shawn Colmes, his family, his attorneys, give us insight into that courtroom. Stay with us here on Law and Crime. We'll be right back right after this.